Hello everyone, welcome to Drishti CUET undergraduate program and I am your mentor Shashank. Learners, in today's session I will be discussing with you a very important topic of Indian polity, and that is fundamental rights. So today I will be discussing with you the topic of fundamental rights, and it's a very important topic related to the GAT section. And in GAT section guys, you know that the three section comes, that is reasoning, mathematics and GK and current affairs. And in GK section in from Indian polity, it is one of the important topics, that is the fundamental rights. So what is the agenda of today's discussion? We will be discussing about the introduction of fundamental rights, ki what fundamental rights is all about, then features of fundamental right, ki what are the features or simply you can say speciality of fundamental rights. Then we will discuss about how fundamental rights are suspended, and then we will discuss about the categories of fundamental rights. So today I will be discussing with you on these four important topics. So let's start the session of today, and first of all guys, let's see where it is mentioned in Indian Constitution. So it is mentioned in part 3 of Indian Constitution, and fundamental rights is called Magna Carta. Magna Carta of Indian Constitution. So it is called Magna Carta of Indian Constitution. Fundamental rights called Magna Carta of Indian Constitution. And Magna Carta, what it was a document that was presented in England. So it was a document presented in England on 15 June 1215 AD, before King John of England, before King John of England. And that document demanded the rights for the people, and this document, that is the Magna Carta, that demanded the rights of the people. Therefore guys, this Magna Carta therefore it demands the right of the people for the two of England. Since fundamental rights also discusses with the right of people, since fundamental rights also discusses with the rights of the people, and Magna Carta also discusses with the rights of the people, so the feature of both the things, whether it is Magna Carta or fundamental right, is same. Therefore fundamental right is called Magna Carta of Indian Constitution, because both discusses with the rights of the people, and King John is called father of fundamental rights, father of fundamental rights. And this Magna Carta, since it was written in which language? So Magna Carta, that was written in Latin language, because Latin was the language of the clergies as well as it was the language of the church. So since it was the language of the clergies and church, and it was considered to be an elite language, therefore it is called, therefore Magna Carta is written in Latin. And fundamental rights guys, this is in part 3, and from which article to which article? So it is mentioned from article 12 to article 35. So from article 12 to 35 there is discussion of Magna Carta. So I hope it is clear to everyone what exactly is Magna Carta, and why part 3 of Indian Constitution is called Magna Carta of Indian. Why part 3 is called Magna Carta of Indian Constitution? Because both discusses with the rights of people, whether it's fundamental rights or Magna Carta. So I hope this is clear to everyone why this fundamental right is called Magna Carta of Indian Constitution. Now, first of all, let's discuss about the things, that is what exactly is the fundamental right. So before I should proceed to the other things, first of all, we should know what exactly is fundamental rights. So we should understand the definition of it, ki what exactly is fundamental rights. See, first of all guys, it is the list of the rights that Constitution of India guarantees all the people living in the country without discrimination. So it is the list of the rights, or simply you can say it is the document of the rights. List of the rights or document of the rights, which is given by whom? So which is given by Constitution of India to the people who are living in India. Actually, who are living in India? So the people who are living in India will be the citizens plus foreigners plus the foreigners. So first of all, the people who are living in India, first of all, are the citizens plus the foreigners. Foreigners who are living in India, and that is given by Constitution of India without discrimination. That means without getting biasness on the basis of gender, whether it's male, female or other one. So first of all guys, it is the list of rights which is given by Constitution of India. Constitution of India to the people who are living in India without any discrimination. And the people who are living in India are foreigners plus citizens, like me and you plus the foreigners. Now foreigners, in the term of political science, they are called aliens. They are called aliens, and aliens are of two types. One is friendly aliens and another one is enemy aliens. So friendly aliens are those aliens, my dear learner, who has, for friendly aliens are those who have those countries, the people of those countries who have harmonious relationship with India. So if the political relationship with India is all good, so the foreigners or the people of those countries, they are called friendly aliens, and enemy aliens are those aliens who have disturbed political relation with India. So the people of those countries who have disturbed political relation with India, they are called enemy aliens. I hope it is clear. So fundamental rights is given to whom? So it is available only to friendly aliens. It is not given to enemy aliens. So it is not given to enemy aliens, it is given only to the friendly aliens. Now guys, demand for fundamental rights. So demand for fundamental rights was raised in 1931 Karachi session of INC, and the president of this session was Sardar Patel. Sardar Vallabh Bhai Patel. So Sardar Vallabhbhai Patel was the president of this session, and the source of the fundamental right, it is USA. So from US Constitution we adopted fundamental rights. So from Constitution of USA we adopted fundamental rights. Fundamental rights is adopted. Fundamental rights are, so from Constitution of America we have adopted the fundamental rights. Is that clear to all of you guys? Then do let me know. And one thing you should always remember, it is available to both. It is available to the Indians plus friendly aliens. It is not available to enemy aliens. It is available to the friendly aliens only. Is that clear? Is that clear to all of you guys? Then do let me know. Then we'll move to the next thing to discuss. Okay, I hope it is clear to all of you. Now let's come to the next thing, that is the features of fundamental rights. Features of fundamental rights, what I mean to say, ki what is so special about fundamental rights. So what are the specialities of fundamental rights that I will be discussing with you, because from the features you will find the question in your examination. Now the first feature is that some fundamental rights are available to citizens only and some fundamental rights are available to the all. And available to the all means it is available to the citizens. It is available to the citizens plus friendly aliens. It is available to the citizens plus friendly aliens. Friendly aliens means ki foreigners of those countries who have good political relation with India. Now guys, the fundamental rights are available to the aliens. Which are the fundamental rights? So example is Article 14, Article 20, Article 21, Article 21A, and from Article 22 to Article 28. These are available to the citizens plus friendly aliens. So these fundamental rights, they are available to the citizens plus the friendly aliens, and friendly alien means those people who have good political relation with India. Now guys, which are the fundamental rights which is available to the citizens only? The fundamental rights which are available to the citizens only, that is Article 15, Article 16, Article 15, 16, then you have Article 19, Article 29 and Article 30. So these are the fundamental rights which are available only to the citizens. They are not available to the foreigners. So the fundamental rights which are available to the citizens, not to the foreigners, are Article 15, 16, 19, 19, then we have Article 29 and Article 30. So these are the fundamental rights which are available to citizens, and Article 14, 20, 21, 21A, and from Article 22 to 28, these are available to the citizens plus friendly aliens. I hope it is clear. We will discuss about these fundamental rights in our coming session. Other than this guys, some rights exist with exception and some rights don't have exceptions. So it is said that some rights are absolute and some rights are relative. Absolute means the rights which have no exception. That means you have to implement as it is written. So example guys, if I take Article 17 that discusses with the abolition of untouchability. Abolition of untouchability. This you will find that that does not exist. So it has no exception. So it has no exception. So it is absolute in nature, it has no exception. While some rights exist with exception. Let me give you an example. Article 18, that is abolition of titles. Abolition of titles. Now guys, if you will learn about Article 18, you will find that the articles that create artificial social barrier, the articles that create artificial social barriers, they are to be removed only. Like article, like the titles of Rai Bahadur, Khan Bahadur, Sir, knighthood. So these type of titles which were earlier given by British government to the people who are educated or to those people who are very rich, so that they should not help the national movement, and national movement should get suppressed and they should rule the country as much as they can. So these type of titles they were awarded. Now after independence, when Constitution of India was implemented, these all titles were abolished. However, Article 18 has exception. So exception is military and academic titles. Military and academic titles can be retained. So military and academic titles can be retained. That means ki military titles, like if a military officer is winner or if a military jawan is winner of Paramveer Chakra, so he can write before his name Paramveer Chakra. If he has won Shaurya Chakra, Ashok Chakra, so that can be used with the name. Whereas academic titles like doctor, if you complete MBBS or if you do PhD, then doctor title is awarded. Other than this, CA, if you complete chartered accountancy, then you can write CA before your name. Same applies with the company secretary as well. Company secretary, they can write CS before their name. So you will find that the military titles and academic titles are retained. Other than this, rest of the title they are removed from, they are abolished. So this is that exists with exception, whereas article 17 that does not exist with exception, that in none of the condition you are allowed to practice untouchability. I hope it is clear. Now next we have that they can be justiciable in court of law. So they can be justiciable in court of law means if fundamental rights are hampered, if fundamental rights are hampered, person can approach to Supreme Court and High Courts for enforcement and safeguard of their fundamental rights. So the person, if the fundamental rights are being hampered, guys, the person can directly approach to Supreme Court and High Court for enforcement and safeguard of their fundamental rights. And these can be done through two articles. One is Article 32 for the Supreme Court and same Article 226 for the High Courts. So I hope it is clear what is the meaning of justiciable. So if fundamental rights are hampered, you can directly, or a person can directly approach to Supreme Court and High Court for enforcement and safeguard of their fundamental rights. Next is they can be amended by Parliament. So Parliament has power to amend the fundamental rights, since Constitution can be amended only by Parliament. So fundamental rights comes in Constitution. So Constitution, the power to amend the Constitution is with the Parliament. Example can be article, example can be through 44th Amendment Act 1978, Article 31, Article 31, which was earlier right to property, was shifted to Article 300A, that is right to property. Now right to property, which was earlier in Article 31, now through 44th Amendment Act, it is shifted to Article 300A. Earlier it was in Part 3 of Indian Constitution. Now it is in Part 12 of Indian Constitution. So they can be amended by Parliament. Other than this, you will find one more example. It is 6th Amendment Act 2002 added Article 21A. This is called right to education. This is called right to education. That is, free and compulsory education will be provided to the children up to the age group of 6 to 14 years. That is, primary education will be provided. I hope it is clear. Next is they can be suspended during emergency. So they can be suspended during emergency, and they are suspended through two articles. One is Article 358 and Article 359. So from Article 358 and Article 359, simply, my dear learners, the fundamental rights can be suspended, but it can be suspended only during emergency. And power to impose emergency, it is in the hand of center. So you should always remember the power to impose emergency or power to declare emergency, it is in the hand of center. So it is in the hand of center. So it is the power of the center to declare emergency, and fundamental rights, guys, they are suspended during the time of emergency from Article 358 and Article 359. So I hope it is clear to all of you ki how they can be suspended. So they can be suspended through Article 358 and 359. I hope it is clear, guys. The features, they can be justiciable in court, they can be amended by parliament, they can be suspended during emergency. I hope it is clear. Now let's discuss ki how through Article 358 and 359 fundamental rights can be suspended. So now we will discuss the topic, that is suspension of fundamental rights. So how fundamental rights are suspended through Article 358 and 359. Now see what Article 358 says. Article 358 says that whenever national emergency is declared, fundamental rights under Article 19 that discusses with the sixth democratic freedom is automatically get suspended. So whenever national emergency is declared, national emergency, guys, it is defined in Article 352 Part 18. Part 18, Article 352 Part 18. Now, if you will read about, guys, national emergency, that I will discuss with you as well. So national emergency, it is imposed in three conditions. First is war, second is external aggression, and third is armed rebellion. Third is armed rebellion. So national emergency is imposed on three conditions: war, external aggression, and armed rebellion. Now, see one thing which is very important. If the national emergency is declared on the condition of war and external aggression, if national emergency is declared on the condition of war and external aggression, then only the fundamental rights under Article 19 is suspended. So whenever, guys, please make a note of this ki whenever national emergency is declared on the condition of war or external aggression, then only fundamental rights under Article 19 is suspended. If national emergency is declared on the ground of armed rebellion, the fundamental rights under Article 19, U by A means under article, does not get suspended. So if national emergency is declared on the ground of armed rebellion, then fundamental rights under Article 19, that does not get suspended. Is that clear to all of you? In which condition fundamental rights under Article 19 that discusses with the sixth democratic freedom are suspended, and in which condition fundamental rights under Article 19 does not get suspended in the time of national emergency. I hope it is clear. And national emergency, it is imposed till now three times: 1962 Indo-China War, 1971 Indo-Pakistan War, and in 1975 by Indira Gandhi on ground of internal disturbance, and through 44th Amendment Act 1978, internal disturbance was replaced by armed rebellion. So I hope it is clear. Now come to the next thing, that is Article 359. Article 359, what it says ki President by a special order or separate order can suspend all fundamental rights except Article 20 and 21. So President can issue a special order. President can issue a special order and can suspend all the fundamental rights except Article 20 and 21. Why Article 20 and 21? Because if you will suspend Article 20 and 21, it will be against the principle of justice. So if you will suspend Article 20 and 21, this will be against the principle of justice. So this will be against the principle of justice. Therefore, Article 20 and 21 can't be suspended even during emergency. So this question comes multiple time in examination, which two fundamental rights cannot be suspended even during the time of emergency. So that is Article 20 and 21. Why? Because if you will suspend Article 20 and 21, it will be against the principle of justice, and this was being provisioned through 44th Amendment Act 1978. So through 44th Amendment Act 1978, it was being provisioned that Article 20 and 21, it cannot be suspended even during the time of emergency. So it cannot be suspended even during the time of emergency. I hope it's clear to all of you. I hope it's clear to everyone. Okay. So this is about, guys, the suspension of fundamental rights. Now let's come to the classification of fundamental rights. Let's come to the classification. Now, if you will classify fundamental rights, guys, in original constitution, it was total 7. Original constitution means कि the constitution that was adopted on 26 November 1949. So this constitution, that is called original constitution, which was adopted on 26 November 1949. So in original constitution, total 7 fundamental rights were there, and present constitution, the number of fundamental rights is 6. So now you have to answer ki we have only 6 fundamental rights. Original constitution we have 7. Right now we have 6 fundamental rights. So in this topic, I will be discussing with you all fundamental rights, that is total 7 fundamental rights which were mentioned in original constitution, and then I will tell you ki which fundamental right was repealed. So then it will be 6. I hope, guys, is that clear to all? I hope it's clear to all of you. Now, see, let's see the 7 fundamental rights. First is right to equality. Right to equality, from which article to which article it was? So it is from article 14 to 18. This type of question comes in match the following, from which article to which article, which fundamental right is there. Right to equality, article 14 to 18. Right to freedom, article 19 to 22. Then we have right against exploitation. This is article 23 and 24. Right to freedom of religion. Right to freedom of religion, article 25 to 28. Cultural and educational rights, article 29 and 30. Then we have right to property, article 31, and right to constitutional remedies, that was in article 32. So these are 7 fundamental rights. Now, guys, as I have told you that right to property, was repealed by 44th Amendment Act 1978 and was shifted to article 300A, and A is capital letter, part 12. Part 12 that discusses with the finance, property, contract and suit. So this is the subject matter of part 12. So right to property, that was defined in earlier, it was in article 31. Now it is repealed by 44th Amendment Act during the time of Janata Party government. So that was during the time of Janata Party government, and it was shifted to article 300A, part 12, article 300A, and in chapter 4. So part 12, chapter 4, article 300A, right to property was shifted. So now, guys, it became now, so now we have 6 fundamental rights. So earlier, which was a fundamental right, now it became a legal right. So what is the nature of right to property? What is the nature of right to property. Earlier it was a fundamental right, now it became a legal right. So legal right, what type of right it is? Legal right is that right which you get after attaining a certain age, and it can be taken by government also. But fundamental rights are those rights which you get once you are born in India. And other than this, if you are not a alien enemy, if you are from the friendly aliens, and if you are born in India, that is by born citizen of India, your parents are Indians, so then you will get the fundamental right by birth. So fundamental right we get by birth, whereas the legal right that we get after a certain age. So is that clear to all of you? Is it clear to all of you guys? Then do let me know. Then we'll move to the next thing. Is that clear to everyone? Okay. Now guys, let's come to the articles. First is guys Article 12. I have told you that fundamental right starts from Article 12 to 35. So first of all guys, we will discuss Article 12, and Article 12 discusses the definition of state. Article 12 discusses the definition of state. Now, you might be thinking, sir, India is a country, and why it is a state? Why not it is country is being defined? Because what we have read from our junior school till now, India is a country. Now guys, if I talk about the definition of state, here state means what? So here state means India as a state. India as a state. And whatever the definition of state is given, whatever the definition of state is given in Article 12, same definition is mentioned, same definition applies in Article 36, that is definition of state. It is same in part 3 and part 4. So definition of state is same in part 3 and part 4, and it is India as a state. It is India as a, and this definition is of India as a state. I hope it is clear what is defined in part 3 and part 4, that is India as a state. Now guys, in rest of the places, state means 28 states of India, but in the rest of the areas, rest of the parts of Indian Constitution, state means 28 states of India. State means 28 states of India. Here, rest of the parts, you will find that Indian Constitution 28 states means, state means 28 states of India. But in part 3 and part 4, especially in Article 12 and Article 36, state means India as a state. Now, how we can say that India is a state? So first of all guys, I will take you to a political science so that you should understand. So let's divert the topic from constitution to political science. Now guys, if you will find that what is a state? So first of all, there is a very famous political scientist of USA whose name was, there was a very famous political scientist, political science expert of USA, whose name was James Wilford Garner. James Wilford Garner, he gave the definition of state. So James Wilford Garner gave the definition of state, and he defined a state. And James Wilford Garner said that ki state has 4 components. So he said that ki state has 4 components. Which are those 4 components? First is defined area. Then he said defined population. Third is a government to rule. And fourth, he said sovereignty. So for the fourth, he said that the fourth should be sovereignty. So for the fourth, he said sovereignty. Fourth, he said sovereignty, and sovereignty can be defined into two parts. One is internal, and second is external. One is internal and second is external. Now just compare on these four parameters India and 28 states of India and 28 states of India. Just compare India and 28 states of India on these parameters. On these parameters, guys. First is defined area, then defined population, a government to rule plus sovereignty. And sovereignty internal and external. Internal and external. See, first of all, India has a defined area. We all agree that India has a defined area. Yes, every state of India has a defined area. So India has a defined area. Agreed. Every state of India has a defined area. Agreed. India has a defined population. Agreed. Every state of India, they have defined population. Agreed. Now in India, we have government to rule. India, since it is ruled by government of India, that is central government, and the states are ruled by respective state governments. Next is sovereignty. Sovereignty means what? Sovereignty means independency. Sovereignty means independency. Now guys, if you will see that in India, do we have internal sovereignty? That means, does government of India can make law for any part of India? Yes. Does the state government can make law for their own state? Yes. Now, do government of India can make foreign policy? Government of India can make its own foreign policy? Your answer will be yes, because we have Minister of External Affairs. Do state governments can make their own foreign policy or can collaborate with any foreign country without taking permission of government of India? Do state have Minister of External Affairs? No. So state do not have external sovereignty. So guys, what we concluded that India completes the parameter of being the state. So in terms of political science, India is a state. And these 28 states, since they do not comply with the all parameters of the state, so these 28 states are termed as provinces in term of political science. But in our constitution, state is defined as the country and the provinces, they are defined as. So therefore guys, I told you ki it is India as a state, it is not the 28 states of India, because India fulfills all the parameter of being the state. So what exactly these are things? Government and Parliament of India, government and legislature of the state, all local authorities, and statutory and non-statutory organization. These are the components of the state. These are the components of the state. Government and Parliament of India. Parliament of India comprises of both the houses, that is the both houses, that is Rajya Sabha, Lok Sabha. Then government and legislature of the state. Legislature, we have two houses in 6 states, that is called Legislative Council. Second is called Legislative Assembly, that is called Vidhan Parishad, Vidhan Sabha. All local authorities. Local authorities, whether it's urban, this is municipality and municipal corporation. And rural, gram panchayat, panchayat samiti, plus zilla parishad, plus all statutory and non-statutory bodies. Statutory bodies are those bodies which is created by act of parliament. Now guys, we will be discussing the next article, that is article 13. So what article 13 says? That the law which is inconsistent with the fundamental right shall be declared void. That means the laws which are against the fundamental rights, that will be declared void. So that simply means that the laws which are against the fundamental right will be declared void. So the laws that is made by parliament or by state legislature or by executive order, and if they are against the constitution of India, if they are against the fundamental rights, so the laws which are against the fundamental rights will be declared void. So will be declared void means ki will be nullified. Now guys, because the fundamental rights, they are the rights of the people which is given by Constitution of India, and if any right which is against the fundamental right shall be declared void. And it does not, and do not think that guys ki the laws can be made either by parliament, either by state legislature or by executive order, and it is against the fundamental rights, then it will be declared void. And which authority has power to declare the laws void? So the authority which can examine the fundamental validity of the law, whether the laws are complied with fundamental rights or not, and this is the Supreme Court and High Courts. That means the higher judiciary. The higher judiciary has power to examine the validity of the law, whether these laws are against the fundamental rights or they follow the fundamental rights. So the laws which are against the fundamental rights, that will be declared void. And the laws made by parliament, that includes the amendment also. So laws made by parliament including constitutional amendments, So this is called doctrine of judicial review. This is called doctrine of judicial review. This is called doctrine of judicial review, guys. I hope it is clear. This is called doctrine of judicial review. Next we have Article 14. That the state shall not deny any person equality before law and equal protections of law. So the state shall not deny any person equality before law and equal protections of law. I hope it is clear. Now what is equality before law? Equality before law is that is everyone is equal. Everyone is equal in eyes of law, and it is adopted from Britain. So it is adopted from Britain. But in India, guys, everyone is not in same in the eyes of law. Like we have president and governor, they have given immunity that if a president and governor does any type of crime while in the office, that means ki while sitting on their respective post, no civil and criminal case can be filed against them. So there is discrimination. So simply, guys, you will find that there is an exception, therefore it is negative. Equal protection of the law, it is adopted from USA. Adopted from USA, that means equal treatment in equal circumstances. Equal treatment in equal circumstances, and this is there is no exception. Therefore, it is positive in nature. So this is, since it has no exception, so it is positive in nature. So it is a positive concept in nature. So the state shall not deny equality before law and equal protections of law. Therefore, guys, in India, we both have equality before law plus equal protections of law. So this is the concept of equality before law and equal protections of law. Next, we have Article 15. Article 15 simply says that the state, here state means India as a state. Here the state shall not discriminate people on the basis of religion, race, caste, gender and place of birth. So on the basis of religion, race, caste, gender and place of birth, the state will not discriminate. But we have the exception. Exception is कि however state can make, however state can provide, however the state can provide special provisions for women and children. Special provisions for women and children. And you will find that ki place of birth, that in simply you can say domicile, can be a qualification. So can be used as essential qualification. Can be used as essential qualification. So the place of birth can be used as essential qualification. Like, guys, you will find that in buses and metros, in railways, the special seats are reserved for ladies. Like for children, Article 21A, that is free and compulsory education to children up to the age group of 6 to 14 years can be made. Other than this, you will find that the place of birth, or you can simply say domicile, can be made an essential qualification, that if you are residing in a particular state, then only you are able to apply for the government jobs in that state. It can be made a essential qualification that depends upon state to state. Other than this, next is Article 16, that says equal opportunity in public employment. Public employment simply in terms means government services. So equal opportunity in government services, guys, but we have exception that however reservation can be given to socially, educationally and economically backward communities. Social and educational backwardness, this is for SC/ST reservation. SC/ST reservation. And economic backwardness for OBC, that is called creamy layer, non-creamy layer. Plus EWS reservation. Plus EWS reservation, that you will find that is given on the basis of economic basis. Like for EWS OBC reservation, if you are in non-creamy layer, so your annual income should be less than 8 lakh rupees in a year, and same that is with the EWS community. So guys, you will find that we have the reservation is ST reservation 7.5%, SC reservation 15%, OBC 27%, EWS 10%. So EWS we have 10%. So overall we have 59.5% reservation. So overall we have 59.5%. So overall we have 59.5% reservation. 59.5% reservation. I hope guys, is that clear to all of you, that overall we have 59.5% reservation. Next is Article 17. Article 17 simply says abolition of untouchability. Abolition of untouchability, and it is absolute right in nature. Absolute right in nature. And absolute right means that the right, it has no exception. So it has no exception at all. So it is of no exception. Next we have Article 18 that discusses with the abolition of titles. Abolition of titles, which titles has to be abolished? That creates the title which create artificial social barrier. Like example of titles can be Rai Bahadur, Khan Bahadur, Sir, Knighthood. So these titles, they have to be get abolished. But we have exception that military and academic titles can be retained. Military and academic titles can be retained. So military and academic titles can be retained, guys. Other than this, no third type of title is allowed by Indian Constitution to get used. So other than these two titles, then no third titles can be used. Is that clear to all of you? Okay. Now let's come to the next article, that is Article 19, that discusses with the 6 democratic freedom. So in original constitution that was adopted on 26 November 1949, we have 6 democratic freedom. That was originally we have 7 democratic freedoms. Now presently we have 6 democratic freedom. Now what sometimes guys, the examiner, they ask you to arrange these freedoms, democratic freedoms, in a sequential manner. To arrange these democratic freedoms in a sequential manner, just to remember the trick, that is Samrat, SAAMRAT, that discusses with all democratic freedom, and just we have one democratic freedom we have to remove. Like for the S, we have freedom of speech and expression. So Article 19 clause A, freedom of speech and expression. So this is S. Then 19 clause B, freedom to assemble peacefully. That is A. Then freedom to form association. Again A. Then freedom to move freely throughout the India. So it is M. Freedom to reside in any part of India. Reside in any part of India. That is R. Then freedom to acquire, hold and dispose of property. This is again A. And freedom of trade, profession and occupation. This is T. So this is Samrat. Now guys, these all rights are all 6 democratic rights. Are subject to reasonable restrictions. So all these 6 democratic rights are subject to reasonable restriction. It means that the reasonable restriction are imposed on all these fundamental rights. That means they are not absolute in nature. That means they are not absolute right in nature. I hope it is clear. They are not absolute right in nature. I hope it's clear. Now guys, this freedom of speech and expression, it includes freedom of press. So it includes freedom of press. Freedom of press is included in freedom of speech and expression. That includes freedom of press also. So freedom of speech and expression includes freedom of press. I hope it's clear. Now let's come to Article 20. Article 20 says that ki protection in respect of conviction in certain offenses. That simply means guys if a person has committed any offense, then also will get some constitutional safeguard. It simply means if a person has did any type of offense, then also the person will get the constitutional protection. Then that person will also get the constitutional protection. That means if a person has did any type of crime or has committed any type of mistake, then also that person will get the constitutional protections. It does not mean if you have committed any type of mistake, all your constitutional protections will be removed and you will be directly prosecuted. And which are the constitutional protections? Which are the constitutional? Which are the constitutional protections? First is no ex post facto law. No is second is no double jeopardy. Third is no self incrimination. No self incrimination. So these are the 3 constitutional protection. No ex post facto law means if the crime, whenever the crime is committed, at that point of time, whatever the prevailing was the law, whatever the law was prevailing, the trial and punishment, if it is given, that will be according to that law. That means ki whatever the during the time of commencement of crime, whatever the law for that crime was available, during that point of time, the trial and punishment, if it is given by judiciary, then it will be according to the law which was prevailing at the time of commencement of crime. That means that it will not be treated with the new law. Next is no double jeopardy. No double jeopardy simply means one crime, one punishment. That means not to be punished twice for the same crime. Not to be punished twice for the same crime. And third is no self-incrimination. That means you are not supposed to provide evidence against yourself. So collecting the evidence, it is the work of police. or any other investigating agency, so they will collect the evidence. The investigating agencies or the police will not compel you to provide evidence against yourself. I hope it is clear. So this is Article 20. Next we have Article 21, that is right to life and personal liberty. So right to life and personal liberty, and right to life, guys, it simply means right to life can be taken. So right to life, guys, can be taken by process established by law. So the right to life can be taken by process established by law, and right to life does not include right to die. Right to life does not include right to die. Therefore, guys, you will find that ki euthanasia is allowed, but active euthanasia is banned. Active euthanasia is banned, and passive euthanasia is allowed. So active euthanasia is banned, but passive euthanasia is allowed, but it has to be fulfill all the terms and condition. So giving passive euthanasia also, it is being allowed by Honorable Supreme Court, but it cannot be given easily. But it cannot be given easily. And personal liberty. Personal liberty includes right to privacy. That is case Puttaswamy versus Union of India case. You must have heard. Justice case Puttaswamy, when he got retired, he advocated for the right to privacy, and he was former judge of Karnataka High Court. Now guys, Article 20 and 21, these two rights can't be suspended during the emergency, because if you will suspend these two rights, this will be against the principle of justice. So if you will suspend Article 20 and 21, this will be against the principle of justice. Therefore, Article 20 and 21 cannot be suspended even during the time of emergency, and this is provisioned through 44th Amendment Act 1978. So this was being provisioned through 44th Amendment Act 1978. I hope guys, is that clear to all of you? So in first session we discussed about these fundamental rights. So let's do practice some questions. First is ki which part of Indian Constitution is called Magna Carta of Indian Constitution? So which part is called Magna Carta of Indian Constitution? Part 2, Part 3, Part 4, Part 5. So correct answer will be, guys, Part 2, Part 3. This is fundamental rights and called Magna Carta of Indian Constitution. Part 4 is directive principles of state policy. Part 2 is citizenship. And Part 5 is about the union. So correct answer will be option 2, Part 3. Next we have the concept of fundamental right is adopted from Constitution of which country? So concept of fundamental right is adopted from France, US, South Africa, Ireland. So it is adopted from USA. So correct answer will be option 2. This is US. Next is the abolition of title is mentioned in which article of the Constitution? Is it Article 12, 13, 17 or 18? And abolition of titles, I have told you it's an absolute right. It is does not have it's abolition of titles. It exists with exception, and that is Article 18. So correct answer will be Article 18, and Article 17 is an absolute right that discusses with the abolition of untouchability. Article 12, this is definition of state. Article 13, that discusses with the judicial review. Now next is ki doctrine of judicial review is adopted from Constitution of which country? So doctrine of judicial review, as I have told you in the previous topic, that is defined in Article 13. It is defined in Article 13 of the Constitution, and it is adopted from USA. It is adopted from USA. Next is कि right to property was removed by 44th Amendment Act 1978 and shifted to which part of Constitution? Right to property. Part 5, Part 6, Part 7 or Part 12? So it was shifted to Part 12, Article 300A. Part 12, Article 300A. So correct answer will be option 4. Correct answer will be option 4, Part 12. So guys, with this I conclude the session for today and I hope you must have found the session interesting and informative. So let's meet in the next session where we will discuss remaining parts of the fundamental rights. So that was all for today. Let's meet in the next session.